Okay. On a request by Sri S. Chettiar, Learned Standing Council, CGST. Oh, you're for the petitioner. Each again say, oh, you're for the APDCL. Okay. You want time? Why do you want time? Rejoinder. Okay. Heard Sri S. Chettiar, Learned Council for the petitioner who has submitted that the APDCL has filed the affidavit against which a rejoinder is required to be filed. He accordingly prays for and is granted 3 weeks' time. Separate orders, huh? List on, we give a date. 1, 2, 3. We'll have it on 6th of April. On a request made by Sri S. Chettiar, Learned Standing Council, Income Tax Department, matter is adjourned by 2 weeks to enable filing of affidavit in opposition. List on 27th of March. Letter which year? 25. Wait. What is the urgency? What construction? When was it last listed? See, mention memos are only meant for urgent matters. Motion we allow, but for unless it's extremely urgent, we don't allow mention memo. When did you file application? Let us see the application. Let us see the application. Bring a copy tomorrow, we'll see. Yes. Motion. Eviction. File. Okay. Okay, I have to bring it in the before the court rises. Motion. (22) matter. Okay, what is the urgency? No, that is not an urgency. What is the urgency? What is the subject matter? 22 matter. Okay, we'll have it on Monday next. Motion. Motion. Okay. Yes. Yes. Who is the engaged counsel? Okay. Have you informed the Public Works Department? Okay. When do you want? On a request made on behalf of the petitioner, matter is adjourned to be listed on 16th of March. Yes, madam. Supply list. Who has filed affidavit, madam? Okay. Your PP Das. Ms. PP Das, Learned Counsel has submitted, Learned Counsel for the petitioner has submitted that the respondent number 5 has filed an affidavit against which a rejoinder is required to be filed. Full stop. See accordingly prays for and is granted 2 weeks time or 3 weeks. Tell us. 3 weeks time to file such affidavit. Full stop. List on 30th of March. 33. 1-4. On behalf of whom? Why are you seeking passover? Why are you seeking passover? On a request made on behalf of Sri N.J. Datta, Learned Counsel for the petitioner, matter is adjourned to be listed on Friday. 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 Date. Friday will be 28/20. No, Friday 20 mat dijiye. And then no 13, on 16th. 13th, 16th. We're having on Monday next. Friday ko kiss matter. Yes. When do you want? Today? Yes, Mr. Where is Mr. The transport department? I mean the forest department. Forest. Forest name shown or not? Reflected. Mr. Khalid, can you wait for a while? Let us have the presence of the forest department. Okay. Mr. Hendrik, please ensure that forest department is here. Okay. I didn't want to. Purana matter. Hmm? Which senior in the court, inside the court? Where is he gone? What is the matter? He was around. We just saw him. Madam Upadhyaya for whom? 6. Let us hear the petitioner. We have seen your affidavit 19/9/2022. Let us see what is the case of the petition. Yes, madam, what is it? One, six. Let's see. Which order is put to challenge date? AVR. What has happened? What by that order? What was done? The respondent number 6 was the appellant in the ABR. He had his appeal was allowed, and the mutation which was cancelled was restored. You were a party in the proceeding. Yes, your senior has come. Mr. Roy, come. If you want her to argue she was doing well, whatever. Up to you. You have challenged an order of 26/11/2015 of the Assam Board of Revenue, by which the mutation in respect of the respondent number 6 has been restored. It was cancelled. He has put it to challenge in the appeal. Appeal has been allowed. You are not made parties in the appeal. You had got yourself impleaded subsequently. That is your case. Who are you? Hmm? Allotted? 30 years. $1977. Yes. It was allotted. It was allotted in your favor. You had applied for allotment of the land which was under your possession. Was it allotted to you? Okay. Okay. Thereafter, yes. This allotment, when did you apply for allotment before the Deputy Commissioner at Tinsukia? When, which year? You can just tell us the year. 2007. Okay. And this spot verification was made upon your application. Okay. It was found that they were not in possession, HLL. Hmm. Years thereafter? And lecture one is page 39. 39. 22nd of June. So your application was not in 2007. You had applied before that. You said 2000? No, you said you applied for, we asked, when did you apply? You said 2007. I think you had applied much before that because there was some movement of Orders were passed in 2005. You must have applied, at least it has to be before 2005. Anyway, you read 39, you were at 39. Yes. 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 This last line we have not understood. It will be convenient to grant mutation to the residents. Residents means your clients. If they get registered deed from Dumduma India Limited. But you are supposed to have a registered deed of transfer. If you fail to submit, if you fail to submit your objections, you have missed one line. If you fail to submit your objections, madam, there is one line. If you fail to submit your objections, comments, etc. within 10 days from okay. Thereafter, Yes. Okay. It is okay. You have submitted. Thereafter, you got yourself impleaded. You got yourself impleaded subsequently. Thereafter, hmm. Page, page. Yes. Yes, yes. Yes. Expression used is possession of interest. The expression in 116 we are just examining. We can you please read 116? Power of Deputy Commissioner to order the name of a proprietor, etc., to be struck off of register. Do you have it? Whenever it comes to the notice of the Deputy Commissioner that any person whose name is recorded in the general register as proprietor, settlement holder, or manager of an estate is no longer in possession of any such interest. That is the expression used. No objection from the. Suppose, Mr. Roy, we accept your proposition that since you were in possession of the land even before the allotment to HLL was given, so the question of they being in possession, which is one of the ingredients, is not fulfilled, and therefore their name could not have been mutated. That is to could not have been muted. That is your now. What about the aspect that so far as you are concerned, you say that you are in possession since the year 1950. But what is your title over the land? No, you have to. No, no, you have to. You have adverse possession. There has to be some recognition by the court. There has to be a decree. Only by possession. Okay. So that is only with Mr. Roy. That is only with respect to the aspect of possession. What about the title? Now, Mr. Roy, you have just narrated your own submission that three things are necessary for grant of mutation. First is title, second is possession, third is any objection. Now you are in possession. There may not be any difficulty in accepting this. But so far as title, where is the title? No, no, allotted. Let, where is the allotment order? Page. $71. Yes, please. Now that is we have seen. Come to the resolution. Resolution number 72. Resolution is recommended subject to further verification. There has to be an actual allotment order. Where is the allotment order? No, it was not recommended by the government. It was recommended by the subdivisional LAC. Now, where is the allotment order? One, 113. Okay. Yes. Hmm. No, but in the SDL is here. That we have already seen. You have placed. No, as per in the SDLSC meeting held on 26/9, we have seen 26/9. But thereafter, there has to be an allotment order. That was the recommendation. But how do you declare a land to be ceiling surplus until and unless a proceeding is drawn up? No, no. In a proceeding, unless Ceiling Act 56, yes. No, those will answer in an appropriate proceeding. Those are not the subject matter of challenge, JMOU. It has to be challenged. You can contend that by the MOU, no title can be transferred. That can be, you can be contended. But we cannot say anything against the MOU unless it is a specific matter of challenge. And that we can definitely consider. We'll do. Para 4, para 14. Code of Civil Procedure, CPC. Which one? Yes. What is the provision in the CPC regarding filing of a suit by a corporation? What is the provision in the CPC regarding the aspect of filing of a suit by a corporation? No, do you have the CPC? Order 29? Recital bond Korea niki pisot দিব পাৰো 10 মিনিট পিছত দি দিব No, no, the judgment which you rely upon was before the Companies Act 2013. It's a judgment of which date? Judgment is dated 22/2/2011. Before the Companies Act 2013 had come into being. So it would be following Order 29. No, where is the Where is the authorized word? The director or other principal officer of the corporation who is able to report. The aspect of authorization per se is not there. It may be an interpretation, but the statute does not say about it. It says three things. One by the secretary, one by any of the director, and third is any principal officer of the corporation. Please read. Madam, don't use a phone in the court. It's not so easy. What do you think? You're not even a counsel and are talking on the phone. Don't take it so lightly, madam. These are not so easy things. You are a student. You should know how to behave in a court. You want this to be reported to your college. You have the basic decorum, madam. Young ladies behaving like this. Yes. Perhaps that will not help you, but that's besides the point. We wanted a clarification so far as the CPC is concerned, uh, which deals with a suit or filed by or against a corporation. You said resolution is not there. We'll definitely consider. So what are your grounds of challenge? Hmm. 2010 330. Name, name. But we have read 291. 291 as such does not say like that. You may be correct in contending if it's a decision of a company means there has to be a ratification or approval by the board of directors. But here, if it is signed by a person who is either the secretary or the director or the principal officer of the corporation, then it meets the requirement of Order 29. Yes, please. 126. Yes, please. I have been duly authorized to sign the evidence on behalf of the. That's with Mr. Roy, do not forget that we are exercising 226 jurisdiction. This is not a suit that you are insisting on a document. In a suit, this would be a valid defense, but here we may not insist on a document unless you seriously dispute his authority. Unless you dispute his authority, but he has made the statement. What has been said in this additional affidavit? Additional affidavit. Who is R6? Who is R6? Mrs. Not HLL, not Hindustan. Oh, we'll come to you. That is a R6 is a separate entity, not HLL. MacLeod. Authority. Party here. MKSA is not a party. MKSA, present incumbent, is not a party. Then how do you proceed? Why should they file implement? You have not made them party. Understood. They can come. See, Mr. Roy, they can come for implement. If they come, they will contest the proceeding. If they do not come, when they are not made parties, can it be binding upon them? Say they have acted very wise. Let us be implemented, then we'll come. Unless we are implemented, why should we come? See, Mr. Roy, whatever you say may be correct, absolutely. But once Madam says that there has been an agreement by which the entire interest has been transferred to a third company, third person, whatever is, they are not interested. They are not interested now. Effectively, do not have any interest in this litigation. Litigation has to be defended by one Shah, who is not a party before us. No, that part you may be correct, but that is not the subject matter of challenge. Number one, you have challenged a decision of the board. Thereafter, many changes have taken place. During the proceeding, McLeod came. In fact, it was dismissed for default because HLL was not having any interest. They were not pursuing. It was dismissed for default. McDowell thought that we should since we have stepped into the shoes, and this is an appeal filed by us, our predecessor. So we contest this. We pursue this. They got a favorable result. In the meantime, they also there was further change of hands. Now that new entity is not a party before us. Even if you allow your writ petition, can you enforce it against a third party? I think that will be the best. You can implement, and you can also say that there are no rights have been accrued to them because of this cannot confer any right. Are you in touch with Shah company? Because for all practical purposes, you are not required to even contest this. Whatever you have got from the agreement you have washed off your hands. You will not contest this. And even if Mr. Roy is successful in this venture, it may not be enforceable against Shah. They will say that we are not even a party. He'll be in difficulty. But Mr. Roy, we had spent a considerable time here. Can you file it immediately so that we can at least issue notice and get them? No, part we don't. It'll come before us only, but you file it as soon as possible. Okay. You file it as soon as possible. I will say you'll file, then we'll have the I listed along with this. You should have done this. You should have done this earlier. Hard. That you can do. That you can do. Just a minute. But they will not be interested in pursuing. They have, maybe because of this deed, whatever their consideration part, they have received the consideration. So they will not be, we want to know the position. Now you're in, Are you in possession of the land in question? You're in possession. Okay. An order dated 26/11/2015, passed by the learned Assam Board of Revenue, is the subject matter of challenge in this petition, instituted by 249 numbers of petitioners, full stop. By the said order, the mutation in favor of the respondent number 6 was restored, which was earlier cancelled by an order dated 22/6/2005, passed by the Deputy Commissioner, Tinsukia. Full stop. Para. While the SP Roy, the counsel for the petitioners, has submitted that there are good grounds for challenge, Ms. Upadhyay, learned counsel for the respondent number 6, has informed that the original appeal before the ABR, learned ABR, was preferred by Hindustan Liver Limited. And during that proceeding, the interest was transferred to her client, the respondent number 6. Full stop. She has also informed that in the meantime, the appeal was also dismissed for default, which was, however, restored on an application filed by the respondent number 6 and was subsequently allowed by the order dated 26/11/2015. Full stop. She has also informed that during the pendency of this writ petition, there is further change of hands so far as the business of the tea garden is concerned. And presently, one M.K. Shah is exports is running the business. Full stop. She has also drawn the attention of this court to an affidavit, to the additional affidavit filed by the respondent number 6 on 19/9/2022, wherein the memorandum of agreement, what do you call? Memorandum of understanding dated 5/6/2018 has been enclosed. Full stop. Para. Along with the agreement have been enclosed. Para. Sri Roy, the learned counsel, has submitted that transfers cannot be made simply by a memorandum of understanding or an agreement, and no right will accrue upon the new incumbent. Full stop. However, since the new incumbent is not a party before this court in this proceeding, Sri Roy, the learned counsel, submits that an appropriate application would be filed for implement of the new incumbent. Full stop. In that view of the matter, under the peculiar facts and circumstances, though this matter is pending since the year 2018, 10 days time is granted. 10 days, it will be okay for you? Or 2 weeks? 2 weeks time is granted. 10 days time is granted to Sri Roy, to the petitioners, to file appropriate application for implement. Full stop. List this case along with the IA that may be filed. But interesting case. Interesting case. Let us see what happens. ডিসিশনটা মোটটা করে দিবাছেন একটু বলে তো হবে পরে কিন্তু yes, Forest. He is saying that it is covered by withdrawn. Then we'll see. If it is withdrawn, why should he pass this order unnecessary? We'll have record this, okay? Item number heard Pre-J Khalid Learned Counsel for the petitioners. What's the petitioners who are 23 in numbers have put to challenge an eviction notice dated 25/2/2026, whereby they were directed to vacate the land under their possession within 15 days. Full stop. Many grounds, including the aspect that the lands were recorded as Myadipata land, have been urged in support of the present challenge. Full stop. Para. Three R. Gogoi, Learned. Standing Counsel Forest Department has, however, informed this court that the impugned eviction notices dated 25/2/2026 have been withdrawn by the office order dated 6/7/2026. Full stop. This court is of the opinion that in view of the aforesaid development, there is no life cause of action which requires adjudication. Full stop. The writ petition is accordingly adjudication. Full stop. At this stage, Sri Khalid, the Learned Counsel, prays for withdrawal of the writ petition. Full stop. Writ petition accordingly stands dismissed on withdrawal. The copy of the office order dated 6/3/2026 is made part of the records. Yes. Yes, madam. 18 matter, madam. Why should we pass over? Oh, we'll have some other day. Okay. Oh, while Sri K. Pal, Learned Counsel for the petitioner is present, comma, there is a request for adjournment on behalf of Sri NC Das Senior Counsel for the responsibles 2, 3, and 4. Para. In that view of the matter is adjourned to be listed after a week. Madam, 17 March, is it okay? Okay, 19 March. List on 19 March. I can see. Yes. We go 19 matter, we go ahead with the disposal. Yes. But 19 matter, how do you give you time after 7 years? 24 to 26, 2 years. We're not inclined to grant time. 19 matter. If you have got Paravas comment in 2024, what prevented you from filing the affidavit? Okay, 10 days time. But no further opportunity. Third, 3 Day Learned Counsel for the petitioner. Also heard 3 SK Talukdar Learned Standing Counsel, Cooperation Department. 3 T Roy Learned Counsel for the respondent 4 has, however, prayed for some time to file the affidavit in opposition. Para, considering that this writ petition is of the year 2019, as an exceptional case, 10 days time is granted to the respondent 4 to file the affidavit in opposition. List on. We give a date, Mr. Roy. Today is 10th. It's not what? All of a negative, na? All of a negative. Oh. Hello. Not a big holiday. Not a holiday. We'll have it on 20th. 20. Not 20. Not 20. On 23rd. 23rd, you get time. Okay, 23rd. This Thursday, let me go. You say delay the one hour, nothing. This Thursday, taking. Oh, say my take. Item number? The file has gone missing. But there is a request that you can file a fresh application, which will be considered in accordance with law. You file a fresh application, we'll dispose this off. Only direct that once that. Heard 3 J. Sharma, then a counsel for the petitioner. Also heard 3 J. Hendik, learned state counsel. Puts up para. The grievance of the petitioner is with regard to the inaction of the respondent authorities to carry out the demarcation process. Full stop. It is projected that the petitioner had purchased a plot of land measuring 3 katha bracket IE 8.03 ARER covered by DAG number 426 KP Patta number 60 of Borsodai Revenue Village under the Beltola Moza of Kamrup district, and possession was taken over. Full stop. The petitioner has also constructed boundary walls, and the land was mutated in the year 16-1, mutated on 16-1-1995. Since the petitioner had to remain out of station in connection with his service, it was found that some unscrupulous persons had erected temporary sheds inside the boundary, which was immediately informed to the circle officer, Dispur, as well as the deputy commissioner by making a prayer for demarcation of the land. Though a demarcation case was registered as 60 of 2019 and notices issued, no action was taken. Full stop. Para. Do this Sri Sharma, the learned counsel, has submitted that there cannot be any discernible reasons not to finalize and complete the demarcation exercise. Full stop. Para. After issuance of notice, the matter was looked into, and Sri J. Hendrick, the State Council, has placed before this court a recent communication dated 21/2/2026, issued by the concerned circle officer, Dispur Revenue Circle, wherein it has been stated that since the establishment of the Co-District Commissioner's office is in the premises of the office of the Dispur Revenue Circle, the concerned files appear to have been misplaced. It has, however, been undertaken that if the petitioner applies for demarcation with a fresh petition, the same shall be done expeditiously. After perusal of the materials on record and also taking into consideration the stand taken by the concerned circle officer in the communication dated 21/2/2026, the petitioner is granted liberty to submit a fresh application for demarcation. If such an application is done, is made, the same is to be processed and the exercise be completed expeditiously and preferably within a period of 2 months. The copy of the communication dated 21/2/2026 is made part of the records. But you have to apply in accordance with law. Fresh petition in accordance with law. If the petitioner applies, is made in accordance with law, Okay. Okay. None appears for the petitioner on call, whereas Sri S.K. Talukdar, learned standing counsel, cooperation department, is present, who has also questioned the maintainability of the writ petition. What's the para? Even on the last occasion, none had appeared for the petitioner. Para? It appears that the petitioner has lost interest in pursuing this case, such that accordingly the same is dismissed for want of prosecution. Article 6. Yes, Mr. Sharma. Rejection of your complaint before you had lost the complaint. We go for disposal of this, Mr. Doctor. The old matter, 22. Okay. You are H.K. Sharma. You are for Silchar Municipal Corporation. Nowadays corporation. Okay. What is it, please? He was the original land owner. Original owner of the land. Okay. Then what happened? Hmm. With R5 for multi-story building. Then we means you are how many? You are a society. That means members of the society had purchased. Where is this property? You had purchased flats. Thereafter, okay. 3 + 6. Thereafter, in the open space, what was constructed? Another. Who is R4? Okay. Okay. Yes. How are these matters to be adjudicated by a writ court? Hmm. You file a suit. Why? How do you? Why do we? How do you exercise extraordinary jurisdiction? These are all matters of fact, disputed questions of fact. Now, the legality or otherwise has to be adjudicated. Who will adjudicate? You take appropriate action for G plus one. So far as hostel is concerned, that we cannot go in. What is this? See what business you're running, whether in a residential complex you're running commercial. Those are matters which has to be looked into. By we cannot go into those aspects. But G1, G plus one, if there is no permission as such, you take action. Who is R4, madam? Yes, what is your call? What do you say? Who is your senior? Where are they? Name shown. Please call them. We are going to allow this petition. Now, if there was a talk of compromise, Mr. Sharma would have at the beginning said, since he has proceeded, it means that there is no compromise has not materialized. So we'll have to adjudicate this matter, which we are doing. When tomorrow, madam? Next week, before Thursday. Thursday. No, since it has come from you, you're representing the corporation. The question of further adjudication may not arise, but we are just giving a Mazumdar an opportunity. See, these are matters of fact which cannot be disputed. You are the authority. If you say permission is not granted, there is no permission. You take you need to take you take action in accordance with law. Okay. Heard Sri H.K. Heard Sri H.K. Sharma, learned counsel for the petitioner. Also heard Sri S. Datta, learned senior counsel, assisted by Ms. Mosari for the Silchar Municipal Corporation. Full stop. The challenge in this petition is with regard to the inaction on the part of the Silchar Municipal Corporation qua the illegal constructions made by the respondent number 4. Full stop. Sri Dr. The learned senior counsel has candidly submitted that so far as the G plus one construction in the same premise is concerned, comma, the records do not reveal that any permission was taken. Full stop. Miss, your name? DDB. Miss DDB Learned Counsel has, however, prayed for a short accommodation on behalf of our senior, D. Mazumdar, who appears for the respondent number 4. Full stop. Para? 4 and 5. Who is 5? 4 and 5. Para? In the interest of justice, a slight accommodation is granted, directing listing of this matter on Thursday. Please give the date. Thursday, day after tomorrow. Mr. Goswami, go ahead for disposal. Yes, please. P1 has expired. How many petitions are there? Total six. Out of six, one has expired. Okay. What is the market? Bornagar. Gornagar. It's in Kolpara district. Joleshwar. Yes. What has happened? Who are you? Who are you? Market committee. The petitioners are members of the market committee. Other petition. One has passed away. So what about? Now, what is your interest in the cause in the? Yes. Yes. Hmm. Hmm. What is your prayer? Why don't you file in the form of a PIL? Let us see where. Page. Yes. Now, after the direction to consider your representation, what had happened? Where is the disposal of disposal order of the represent 47? Okay. Just a minute, please. 16 July 22. Yes, please read. Please read. Hmm. Hmm. Mr. Goswami? No? No, we would have otherwise asked him to file a PIL, but he is equipped with an order of 9/3/2022 passed, demarcated. It's 51. What is there then? This will be disputed questions. Just a minute. It's 50. Affidavit opposition by R5. Who is R5 circle officer? What have you stated? Where, Mr. Goswami? Yes. Please read. Please read. Yes. Page 48. Then 49 you want to read. Yes. No, Mr. Mullah, this no, this the relevant is not that. Relevant is the date. This is 1/8/2022. Affidavit has been filed on 5/8/2023. Why not? Affidavit is of 5/8/2023. Almost 1 year thereafter. In the affidavit, they have stated that notice is served, demarcation done, eviction removed. Then this will be disputed in the realm of disputed questions of fact. So how do you decide? That has been stated on affidavit by an officer. Have you filed your rejoinder? Have you, Mr. Counsel? Why don't you see the date? What is the date of this order? This may be correct on 11/8/2022. Affidavit has been filed when? 5/8/2023. After 1 year, position has changed. They have stated on affidavit. There is nothing to dispute or disbelieve. Have you filed your rejoinder? Have you filed your rejoinder? Rejoinder, what have you stated? Against paragraph 4? '91. Okay. Just a minute, please. This will come under disputed questions of fact. There is no categorical denial. Even if you assume that deem this to be a denial of some kind, this will come under disputed questions of fact. Why should you transform a writ court into a civil court? You approach the civil court if you still think that there are wrong projection of facts made by the officials. File a civil suit. This affidavit has been filed by whom? Circle officer. Why do you require an executive officer? Yes, Mr. Islam, we are for whom? See, we are going to dismiss it. Don't say something which will lead us to allow this. Something may come out from you which might change the opinion of this court. But who are you? Of what? Shop owners or encroachers association? Association of encroachers, secretary. See, that is why I asked you, do not say anything. Moment you say something, petitioner will find and handle. Okay. Heard Sri A.F.N.U. Mullah, learned counsel for the petitioners. Also heard Sri N. Goswami, learned state counsel. You also, Mr. Doctor, State Counsel, Sri S. Doctor, learned standing counsel, PNRD, and Sri R. Islam Learned Council for response number 7 and 8. Para. As per the facts projected, comma, the petitioners are residents of the locality, and few of them were also holding some position in the Anchalik Panchayat. Full stop. The grievance is with regard to the inaction of the respondent authorities to make the Gaur-Nagar GAUR NAGR Bazaar encroachment free. Full stop. It is contended that an area of 12 bigha, 8 lechas was allotted to the bazaar, which has practically been reduced to about 3 bighas by random encroachment. Full stop. The same has also adversely affected the drainage system and the availability of public toilet and drinking water facilities. Full stop. The petitioners had earlier approached this court by filing WPC 1454 of 2022, which was disposed of by an order dated 9/3/2022 at the motion stage by directing consideration and disposal of the representation dated 5/2/2022. Full stop. It is contended that though the representation was disposed of representation, not earlier representation. Where an order dated? 22? Oh. Dated negative, representation, full stop. Dated negative. It is contended that though the representation was disposed of on 5/2/2022, comma, only certain action towards clearing the road has been taken and the market area still remains under encroachment. Full stop. Sri Mullah, the learned counsel for the petitioners at the outset, has informed that the petitioner number 1 has passed away. However, full stop, the cause of action is a surviving one, which has been espoused, which continues to be espoused by the other petitioners. Full stop. He has submitted that there has been a sham, SHAM, sham compliance of the order dated 9/3/2022 passed by this court, whereby the representation was directed to be disposed of. Full stop. He submits that though an order has been passed on 5/2/2022, comma, no effective steps were taken for making the market encroachment free. In this regard, comma, he has drawn the attention of this court to a communication dated 11/8/2022, issued by the Jaleshwar Anchalik Panchayat, within which the market is situated. Full stop. In the said communication, comma, it has been highlighted that there is large number of encroachers in the market area by constructing dwelling houses, and the demarcation was not yet done. Full stop. Para. Par contra, comma, Sri Goswami, the London State Council, has submitted that in the meantime, comma, a proper demarcation exercise has been carried out, followed by an followed by eviction of the encroachers. Full stop. In this connection, comma, the United State Council has drawn the attention of this court to the averments made in paragraph 4 of the affidavit in opposition filed by the respondent number 5 on 5/8/2023. Full stop. The respondent number 5, who is the circle officer of the Lakhipur Revenue Circle, has clearly stated that an eviction drive was carried out and all the illegal encroachers were evicted and evicted, and the matter was, and the action taken report was forwarded to the district commissioner Gwalpara via letters dated 25/4/2020, via various communications. What's the para? Sri R. Islam, Sri S. Datta, Learned Standing Council, PNRD, has endorsed the submission made by the Learned State Council. Para. Sri R. Islam, Learned Council for the response number 7 and 8, has submitted that the authorities had taken appropriate action for making the market enforcement free. And this part has been clarified in the affidavit filed by the circle officer. Para. Sri Mullah, the Learned Counsel for the petitioners, in his rejoinder, has submitted that the encroachment is still there and public interest is being adversely affected. He has also submitted that rejoinder affidavit has been filed, whereby there is a denial of the statements of the affidavit in opposition filed by the circle officer. Para. The rival contentions. Para. The issue which has been sought to be raised would normally require the petitioners to file a writ petition in the form of a public interest litigation. Full stop. However, considering that an earlier writ petition was entertained by this court and disposed of by 9/3/2022, this court will overlook that aspect. Full stop. The grievance is with regard to the inaction of the respondent authorities to make the Gaurnagar market encroachment free. Full stop. While the bona fide of the petitioners are not in doubt, as the objective appears to be in sync with the public interest, what transpires from the materials on record is that questions of fact have been raised which are clearly disputed by the respondents in their affidavit. Full stop. In fact, in the affidavit in opposition filed by the respondent number 5, circle officer, on 5/8/2023, it has been clearly stated that notices were served, demarcation done, and eviction made. For full stop. For ready reference, the said averments are extracted herein below, page 51, para 4, quote. Though the averments, however, though the petitioners have filed an affidavit in reply denying such statement, this court will be confronted with a situation where there would be disputed questions of fact. Full stop. A writ court is not a court of facts, more so when such facts are in dispute. Full stop. Further, there is no reason to disbelieve the version of the circle officer in the affidavit dated 5/8/2023, as it is otherwise also the sacrosanct duty of the administration to keep public places free from encroachment. Full stop. In that view of the matter, this court is of the opinion that no relief, no case for any interference is able to be made out, more particularly in view of the categorical stand made on affidavit by the respondent number 5, writ petition according to stance disposed of. Item 10. Yes, swear for the respondents. Mr. Goswami, you are there? Okay. Respondent number 8, 9, 10. We can go for the disposal of this matter? Yes. Just a minute, Mr. Pathak, 1 minute, 1 minute. We're ready for disposal? Just a minute. Where is Madam M.M. Kotoki? Yes. What is your prayer? Are you ready with the matter? That is why you were asked, are you ready for a disposal? Where is Madam Kotoki? Is she there in the court? Okay, today we'll adjourn it. We can try day after tomorrow. Day after tomorrow, ask her to come. Okay. Thursday, heard Sri M. Pathak, learned counsel for the petitioner. Also heard Sri N. Goswami, learned government counsel, and Dr. P.K. Goswami, learned counsel for respondent numbers 8, 9, and 10. Footstep. However, Miss, your name, madam? Your R. Kotogi. However, Miss R. Kotogi, learned counsel, has informed this court that her senior Sri Miss M.M. Kotogi is on leave. He has not come, has some medical issues, and prayed for an adjournment. Footstep. List for admission hearing on Thursday, 12. What is the issue? Is it required? Is it required for complete evacuation? What does the rule? What does the rule require? Then how does one runs the business of a piggery? Okay, we'll hear Madam Kotoke day after tomorrow. Okay. 11. 11. Yes, Mr. Sharma, you for whom? B. Sina. Yes, Upadhyay. What is the matter? Where is the page? 64 is the impugned order. Who are you? Who's for? IOC. Okay, we'll have day after tomorrow. If they are not there, we'll be spoiled. Dismiss for default. Okay. None appears for the petitioner on call. Petitioner is on call. Whereas Sri N. Goswami, Learned State Council, and Sri M. Sharma, Learned Council for the respondent number 4, are present. Full stop. In the interest of justice, matter is adjourned to be listed on Thursday. Full stop. It is, however, made clear that in case of further default on the part of the petitioners, on the part of the Learned Council for the petitioners, appropriate orders will be passed. I can continue. Yes, Mr. Doctor. You are staying in the Karbi Angalam district. Okay, we'll come back at 2 o'clock. Are you ready for the matter, madam? Who is to? Who is to? Who are you, madam? Two is who? Revenue Department. You are for the Karbi Angalam. Then whose response is required? Any other response is required? Is it required? On the basis of the existing affidavit, this matter cannot be taken up. Okay, we'll consider it 2 o'clock. I think demarcation done by the KAC. No. 2019. Huh? 2000, you said 29. Cannot be 29. 2000 what? 2019 or what? 19. Okay. Now, what is the cause of action? What is your grievance? Evicted. So what do you need, Mr. Datta? What is your prayer now? What do you need? What are you seeking? But you have already been evicted. So how do we determine that kind of a dispute? Whether it falls within the Hojai district or... Yes, what do you say, Mr. Roy and Mr. Chutia? Mm, mm. Commission has been appointed. What do you say, Mr. Datta? A commission has been constituted by notification of April 2025. And one of the key roles is to adjudicate objections and demands relating to inclusion into or exclusion from the KAAC. That is one of the main rule. You can approach that committee. Mr. Roy? Third, Sri D.K. Datta, learned counsel for the petitioners. Also heard Sri J. Chutia. And also has Sri S.S. Roy, learned state counsel. Semicolon Sri J. Chutia, learned standing counsel KAC. And Miss G. Hadarika, learned standing counsel revenue department. Full stop. The approach to this court under Article 226 of the Constitution of India has been made seeking the following relief. Where court could be. As per the facts projected, the petitioners are the villagers of Nagaon district, which is at the boundary with the Karbi Anglong district. Full stop. The district of Karbi Anglong was notified on 13/4/1951. Full stop. The KAC authorities had initiated an encroachment, drive against encroachment, which, according to the petitioner, transgressed into the Nagaon district, and accordingly, WPC 1584 of 2019 was filed. Full stop. There was a direction, interim direction, not to proceed with the eviction. Full stop. However, when the petition was subsequently listed on 26/6/2023, this court was apprised that the grievance of the petitioner can be looked into as per the land policy of 2019, and therefore the writ petition was dismissed on withdrawal. However, the KAC has again issued notice dated 27/6/2023 for eviction. Full stop. Para. So the Doctor of the Learned Counsel for the petitioners has submitted that the land of the petitioner is not within the Karbi Anglong district, and therefore such lands cannot be the subject matter of any eviction process by the KAEC. Sri J. Chutia, the Learned Standing Council, has however contended that eviction drive has been done by the KAEC authorities confined to the area of KAEC, and it has been done strictly in accordance with law. He has otherwise contended that a notification has been issued on 29/4/2025 whereby 29/5 under paragraph 14 within bracket 1 of the sixth schedule to the Constitution of India, whereby a commission has been constituted under the chairmanship under the chairmanship of Sri B. Kalyan Chakraborty, IAS, Additional Chief Secretary to the Government of Assam, to identify, consider, and evaluate claims, counterclaims, objections, and demands related to inclusion into and exclusion from the Karbi Anglong Autonomous Council. Full stop. He has submitted that in case of any grievance, the aforesaid commission may be approached. Full stop. Para. Both Sri S.S. Roy, the Learned State Council, and Ms. Hazarika, the Learned Standing Council, have endorsed the aforesaid submission advanced by the Learned Standing Council of the KAC. Para. Sri Datta, the Learned Counsel for the petitioners, has fairly considered that since a commission has been appointed by the notification dated 29/4/2025, the petitioner may be granted liberty to approach the same. Petitioner would approach the same. Full stop. He, however, prays for a liberty that if any further grievance exists, he may be permitted to approach this court. They may be. In view of the above, while this writ petition is closed by directing the petitioners to approach the commission, if the petitioners are still aggrieved by any orders passed by the commission, they will have the liberty to approach this court. Is there any interim order? There is an interim order. No, is there any interim order in this proceeding? No. Mm. No. Forest area is one part. No. The forest area is one part, and whether that forest area forms within the KAC is another part. If it is outside, if assuming it is forest area within your district, then you can take action. If it is forest area outside KAC, then also take action and can be taken as per Abdul Khalik. It is no, but whether it's forest area or not, how do you ascertain? He has filed rejoinder or what? You have not filed rejoinder. It is forest area. Huh? No, commission is only with the aspect whether you are a part within the Karbi Anglong or outside. The aspect of forest area is totally different. This court, however, makes it clear that if the area under the occupation of the petitioner is forest area, comma, the appropriate authority, whether it is the KAC or the state government, may take action in accordance with the principles laid down by the Honorable Supreme Court in the case of Abdul Khalik versus State of Assam, reported in 2026 INSC 141 ne case. 14, what is the citation? 141. INSC 141, I think. No, not the SLP. Citation 2026 140. Wait, petition start this program. Only state. Forest meeting. What is this? Tribal belt and block. One case we have decided. One case we have decided will follow the same order. No, that is the we have decided. Yes, we have decided one case. Where is that order? No, even that case, who had moved? Mr. Sikdar had moved. Along with you, he had moved that case. You are on a different footing. He was on a different footing. Here, Sikdar had moved. No, you are not there. In your presence, do you have a copy of the? Hmm? Get it. We have not entertained this petition. We have given limited whatever is entitled to by them. They will be given that scope. We'll grant you protection for reasonable protection as we have been granting in all places, but we're not. It's not a relief as such. And did they so cause? 132. Tribal belts and lobster eviction. Tribal belt and block eviction. 130 is the eviction notice. Yes. Yes. Oh, yes. Oh, this is not, this is after hearing. What are your grounds then? Can you do it? That will be defeating the entire purpose of tribal belt and blocks. $165 of the when was it constituted? No. When was it constituted? As per you, you have to make a. Hmm. Which page? Which page? Yes. Hmm. Hmm. Page? Tribal belt होता है तो महान. अच्छा ट्राइबल बेल्ट क्यों ना खाएगी? अच्छा ट्राइबल बेल्ट PIL तो কথা দেখিছো মই. নাইলে কলে নহব নহয়. অৰ্ডাৰ দিলে পাহৰি গলে হ'ল নি? সেইটো নহয়. ট্ৰাইবেল বেল্ট. ট্ৰাইবেল বেল্ট এণ্ড ব্লকৰ PIL হেৰি কথা লাগিছে. PIL 78 of 2012 কথা লাগিছে. Now, what do you want to show in page 73? Hmm. But in your reply to the show cause, you have taken up this point. Let us see how is the consideration. What is the consideration? Hmm. Yes. They have not come before the court. They are not aggrieved. Let them come. That cannot be a valid submission. If they come, we'll adjudicate. But if you make such an allegation or your foundation is there, then the entire burden is upon you to show that the land is not does not constitute within Chapter 10 of the Land Revenue Regulation. In other words, it is not a part of tribal belt and blocks. When they have proceeded to vacate and you make out a case and you're trying to build up a case that it is not tribal belt and blocks, you are before the court, you have to demonstrate, prima facie, that this area is not tribal belt and blocks. See, you have a GPA, General Power of Attorney, of 2019. You say that the persons from whom you have got the power of attorney, those persons do not appear to be belonging to to the tribal. This is your projection only because they write some Kumar or something. We do not know. And if those persons were in occupation or from the time of their forefather before such declaration, then they are otherwise also protected. Yes, if they were in occupation continuously, you cannot remove somebody. Suppose in the 6th schedule area, a non-tribal was having his land since the time of his forefather. After 6th schedule area has been constituted, you cannot be evicted, but you cannot buy land now. So that is the position. Jawabadi of? No, that is what we are saying. That cannot be a conclusive evidence. If the predecessors of the original owners are in occupation of the land before 1950, which is a possible situation, then it's not necessary that it's only a tribal who can reside there. Non-tribal, provided they are in continuous possession even before the declaration. That is the position. So that will not be an indicative whether it's a tribal area or non-tribal area, only because the original owner is not a tribal. You have to show some other materials. Mm. Please. 113, 130. Yes. Mm. Yes. What else is required? What else is required? Yes. Detailed distributor. Mr. Bhuya, you are there and you said you are not there. What is this, Mr. Bhuya? Which case? The case on tribal belt. What is this? We remembered you. Not escaped. 2nd of March. Today is what, 10? You forget something within 8 days. What is this? Same on the PIL. Oh, yes. What? Whichever is the place. Same tribal belt. Tribal belt and blocks. Same PIL. See the order, you have referred to the PIL. Said you don't remember. So here the exercise is completed. Your case is worse. Will complete. Let him complete. Yes. Page. So how much time has been given? So do you contend that it should have been written that 15 days time is given to you to seek remedy? Why is this 15 days given? 15 days time to vacate, 15 days time not to vacate on the next date. 15 days time to vacate means 15 days. You can also take recourse of law, further law. It's not required to be written that we grant you 15 days time, then we grant you time to vacate. The time to vacate itself will include the time to seek further remedy if you are aggrieved. That has been complied with. 15 days you have 15 days you are there. You are before this court within 15 days. What? Hmm. Nice. Ulan. See, ultimately you get from 9 to 26, 15 days. From 27 to 26, again 15 days. Speaking order gave you 15 days to vacate. Thereafter, notice again on by the circle officer 27/7. Where have you stated? Where have you stated? If you have not stated, then how do you take cognizance of it? No, these are important things. If you have not been communicated, this will form a basis of our decision-making process. Now, if the statement is not even made, difficult. See, Mr. Bhuya, you had moved this out of turn, seeking special permission. We did not ask you to move it today. You had all the time. You prayed, we allowed. You said urgency. Now you cannot say that, no, give us time. We never said we are not going to give you time. Whatever you have presented, you have presented. We are adjudicating on it. Yes, Mr. Proprietary. 77. Yes. Hmm. 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 Yes. 130. Yes. Hmm. We have seen that star patta is there, 39. Dag is 705. No, 705 is there. That 705 is the dag. 706, 6. Yes. Yes, yes. Hmm. Where are you reading? Yes. Hmm. Hmm. Yes. Hmm. 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 This, Mr. Uh, Proprietor, this 130 is 15,925 or 15,915? The signature down below, what is the date? It's 15, I think. 15. 15. It's long time notified. Not 25, 15. 15,915. No, no, type copy you were on the original at 131. What is the date? I think it's 25/9. 25/9. No, no, what is the year? What is the designation of the officer? Homi? Homo? No. The SM is Homogera. That means it has to be 25 because in 15 there was no co-district commissioner. I think Mr. Borbia, this date is not 15/9. This is both are two. 25/9/25. Just see the 131 again. The handwritten date. It's not 15. 25/9/25. Both are 25, not one. Because this has been mentioned in the 132, page 132, 25/9/25. No. 25/9/25. Mm. Mm. Yes. Mm. Mm. Would you like to say anything, Mr.? Yeah. 149. Oh, 141. Yes. Hmm. One. Regulation 160. Which regulation? Regulation number? One 163. Hmm. Where are you reading? 157. This power of attorney was not to afford you any shelter. Have you read the power of attorney? It is almost a land transfer. You can sell the land, you can utilize the land, you can sign and execute for sale, you can see these are dubious means of transferring land without paying the stamp duty, the registration fee. See what you can do. Let us see what you can do to create mortgage, either equitable, simple, to negotiate with intending purchaser of sale, to execute final sale deed. So what remains? What remains? And you are saying that you are landless. You have been given your residing there. It was not given for you to reside. It was not given for you to reside. It was to look after and manage and do all things to required for protection, management, and development of the scheduled land. Okay, okay, okay. Okay, okay. No. We're disposing, dismissing it, not disposing, dismissing it. Mm. No, we have seen that, Mr. Borpujari, that is not required. There is one order which has been given to one individual, and this order which Mr. Bhuya is highlighting, it has got a list The hearing concluded from 15/10/25 to not one day, 22/10/25. And thereafter, by a common order, the list has been enclosed. These are matters of only convenience. This doesn't mean that it has been done in a mechanical way without hearing a single individual. These arguments are not countenanced. We have considered. We have considered. We did not interrupt you, Mr. Bhuya, while making your submission. We have considered your submission. Yes. We are not going to extend time. Sorry, not in this. No, not in this case. This case 4 months was there. It is much beyond the time given by the Honorable Supreme Court. Other cases, we have been giving at least 15 days time. Here, not. Heard Sri A.R. Bhuya, Learned Counsel for the petitioners. Also heard Sri S.S. Roy, Learned State Counsel, and Sri R. Borpujari, Learned Standing Counsel, Revenue Department. Full stop. $135 numbers of petitioners have joined together in this petition, making seeking the following relief. Please quote the relief. Full stop. The challenge is against an eviction order issued, dated 27/2/2026, whereby the petitioners have been directed to vacate the land situated at Pachonia Para village under Dokhin Rani in the district of Kamrup Metro. Full stop. The said eviction is on the ground that the area falls within tribal belts and blocks under Chapter 10 of the Assam Land and Revenue Regulation 1886. Full stop. The petitioners have contended that the area in question is not tribal belt or block, but a revenue land which are under their occupation. Full stop. It is also contended that the impugned action is in violation of the principles of natural justice and the Assam land policy of 2019. Full stop. Para. Sri Bhuya, the learned counsel for the petitioners, has submitted that has at the outset submitted that the petitioners are not the landowners, but are possessing the land on the strength of power of attorneys. Full stop. One of such power of attorney, or one or how much? One. Few of such power of attorneys have also been enclosed to the writ proceeding, writ petition. Full stop. He has submitted that tribal bells and blocks were constituted in the year 1950, and there was a PIL in this code, being PIL number 78 of 2012, which was disposed of on 9/12/2019. However, taking advantage of the said direction, the impugned action has been taken without first ascertaining as to whether the land in question falls within tribal belts and blocks. Full stop. He has also submitted that the said action is in gross violation of the direction of the Honorable Supreme Court in SLP number 2121 of 2020, which has been disposed of wide order dated 3/2/2020. The said SLP had arisen from the order dated 9/12/2019, passed in PIL number 78 of 2012, wherein it has been laid down that the Deputy Commissioner was to give reasonable time to the occupants to take recourse to appropriate remedy as permissible in law. Full stop. He has submitted that while 15 days time has been granted by the impugned order dated 9/2/2026, the same is only for vacating the land and not for seeking appropriate remedy. Full stop. He has also highlighted that one of the notice is dated 27/2/2026, which is issued by the circle officer and is general in nature and not communicated individually. He said he accordingly submits that the petitioners have been deprived of their right to put up an effective defense. Full stop. Para. Per contra, Sri R. Borpujari, Learned Standing Council Revenue Department, has submitted that the area in question falls under tribal belt and block, and the notification in that regard to carry out an eviction process was issued way back in September 2025. Full stop. He has submitted that there was no challenge to the said notification, wherein in a tabular form, the description of the land in question was given, including the dark number and the patta number. He has also demonstrated that the notice for notice directing the petitioners to produce appropriate documents also contains the description of the land which matches with the initial notice of September 2025. And therefore, it will be too late in the day on the part of the petitioner to contend that the area in question does not fall within the tribal belts and blocks. Full stop. Para. By drawing the attention of this court to the initial notice of September 2025, which has been enclosed at page 130, the Learned Standing Council has submitted that from the said date, almost more than 6 months, have elapsed, in which and in between, hearing was held from 15/10/2025 to 22/10/2025, and only thereafter the eviction notice has been issued. Full stop. He submits that there is full compliance with the direction of the division bench in the order dated 9/12/2019 and the subsequent direction of the Honorable Supreme Court dated 3/2/2020, in which the order of the division bench was the subject matter of challenge. Full stop. He has submitted that the aspect of giving reasonable time to the occupants to take recourse to appropriate remedy has been duly fulfilled, in as much as almost 6 months' time was taken for completion of the proceeding, followed by further 15 days' time to vacate the premises. Full stop. The Learned Standing Council has also highlighted the aspect of preserving lands earmarked as tribal belt and blocks, which is also a statutory requirement under Chapter 10 of the Assam Land and Revenue Regulation 1886, which pertains to protection of backward classes. Full stop. Para. Sri S.S. Roy, the learned State Council, has endorsed the submissions advanced by the learned Standing Council, Revenue Department. Full stop. He has highlighted that all procedural safeguards have been given to the petitioners. Full stop. By drawing the attention of this court to the power of attorney on which reliance has been made by the petitioners, he has submitted that from the same, it does not reveal that the petitioners are either landless or any other affected persons, and those have been executed, giving an omnibus power to the petitioners to deal with the land. Full stop. Para 3. Bhuyan, the learned counsel for the petitioners, in his rejoinder, has submitted that Regulation 164 and 165 of chapter under Chapter 10 deals with rights of settlement holders and landholders and ejectment and eviction. Full stop. He has submitted that the conditions mentioned therein are not fulfilled, and the impugned action have not taken into consideration the relevant factors. Full stop. He otherwise submits that a reasonable time has not been granted to the petitioners. Full stop. Para. The rival contentions have been duly considered. Para. The initial notice was issued on 15/9/2025. 15, we didn't get 25 होता है 130. 15/9/2025, whereby it was notified that the area in the schedule is which is a part of the tribal belt and blocks under Chapter 10 of the regulation of 1886 was required to be whereby it was notice was issued on so and so, wherein it was stated that persons belonging to non-protected category have occupied certain plots of land within the tribal belt and block of Pachani Para Revenue Village Sailabha under the Azara Revenue Circle. Full stop. There is also a mention of the communication dated 15/9/2025, whereby the subdivisional commissioner was directed to conduct an inquiry on such illegal occupation of land under the tribal belt and block. Full stop. In course of such inquiry, the said notice was issued categorically mentioning the name of the village, the patta numbers, the dag numbers, and the area involved, whereby the persons in possession of the land thereunder were directed to submit required documents within the time specified as stipulated under section 165, under regulation 165. Full stop. It is to be noted that there is no challenge, no specific challenge per se to the aspect that the land in question is a part of the tribal belt and block. Full stop. The subsequent notice dated 9/2/2026 clearly reveals that hearing was conducted from 15/10/2025 to 22/10/2025, and in which certain documents like non-registered sale deed, Aadhaar card, voter card, ration card, Gaon Pradhan certificate, erosion affected certificate were sub-furnished. Full stop. There is a clear finding that such document would not constitute any evidence to show that the incumbent is it falls under the protected class under chapter 10 of the regulation of 1886. Full stop. The petitioners were accordingly granted 15 days time to vacate the premises. A similar notice was also issued on 27/7/2026, whereby a list, not on 27, a similar notice, where is that? A similar notice has also been issued on 27/2/2026, enclosing a list as annexure containing the particulars of the persons who are in possession, along with the particulars of the land under their possession. Full stop. Though a submission has been made that the notice, the notice dated 27/2/2026 cannot be construed to be a notice on an individual basis, this court is of the opinion that the said notice only conveys the direction, conveys the decision that after hearing there was no satisfactory response, which no satisfactory after hearing the petitioners, the documents produced could not convince the authority to come to a conclusion that the petitioners petitioners were within the protected class under chapter 10. Full stop. The very fact that the said notice contains an enclosure as annexure containing the details of the persons along with the areas under their possession would show that each of the persons were given a hearing, which is also evident from the observations made that hearing was conducted from 15/10/2025 to 22/10/2025 in the office of the Co-District Commissioner, Jalukbari. Full stop. Para. This court has also duly considered the perused the order dated 3/2/2020 passed by the Honorable Supreme Court in SLP number 2121/2020, which had arisen from the PIL dated 78/2012. Full stop. This court is of the considered opinion that the observations made by the Honorable Supreme Court regarding giving adequate time has been duly complied with, and duly complied with, full stop. This court is also unable to accept the submissions made that the procedure adopted is summary in nature, inasmuch as the initial notice was issued in September 2025, in which a full-fledged process of hearing was conducted, leading to passing of the impugned order, full stop. Under those facts and circumstances, this court is of the opinion that after giving all procedural safeguards, the impugned decision has been arrived at, and all the relevant factors have been taken into consideration. Full stop. It is needless to state that while exercising certiorari jurisdiction, this court is to see as to whether the relevant factors have been taken into consideration and the principles of natural justice has been adhered to. In the instant case, it clearly appears that the impugned decision is based on the relevant factors, more particularly in factors which is in sync with the requirements of Chapter 10 of the Assam Land and Revenue Regulation 1886, and the opportunity of hearing was granted to the petitioners. Full stop. In that view of the matter, this court is of the view that no case for interference is made out, and accordingly, the writ petition is dismissed. Not in this case. What is it? Okay. So what orders are required to be passed here? But if it overlaps, only one will subsist, isn't it? So we interfere in the state action. Okay. Anyone for this CGST? You, madam, for Mr. Kyle. Heard we R.S. Misra, Learned Counsel for the petitioner. Also heard Sri H. Barua, Learned Counsel appearing for the state GST. And Miss Ann Kakuti, Learned Counsel appearing in instruction of Sri S.C. Kyle, Learned Counsel for the CGST. Put the para. Considering the facts and circumstances, and also as agreed to by the learned counsel for the parties, the instant writ petition is taken up for disposal at the admission stage. Puts the para. As per the facts projected, our so-called notice was dated 23/11/2023 was issued to the petitioner by the state GST, alleging that during the financial year 2017-2018, the petitioner had availed and utilized input tax credit IT within ITC to the tune of rupees 14,14,657, which is in violation of section 16 within bracket 4 of the CGST/AGST, and therefore, so AGST full stop. During the pendency of the said process, the central GST had also issued a demand cum show cause notice dated 27/4/2023 for the financial year 2017-18 to TO2 2019-20, alleging that the petitioner had availed and utilized input tax credit in violation of the same provision of law. Full stop. The Sri Mishra, the learned counsel, has contended that for the same period and the same figure, two proceedings could not have been initiated. He has submitted that so far as the proceeding initiated by the central GST is concerned, the same has culminated in an order in original dated 14/11/2023, confirming the demand of rupees 1,31,56,521, correct? Which includes interest. He accordingly submits that the CGST, having adjudicated the aspect, the state GST could not have proceeded parallelly. Para. Sri Barua, the learned counsel for the Mr. Chaudhary, would appear? Okay. Sri Chaudhary, the learned learned standing counsel, finance department has fairly submitted that that he will not dispute, that there is no dispute with the factual proposition that there is an overlapping of the period. Full stop. Para. That being the admitted position, this court is of the view that since the proceeding initiated by the CGST has attained finality, there cannot be another proceeding on the same subject matter and for the same period by the state GST. Full stop. Accordingly, the proceeding initiated by the respondent number 3, wide show cause notice dated 23/11/2022 is interfered with and is set aside. Full stop. That's all. Order initiated wide order show cause notice dated 23/11/2022, which culminated in the final order dated 11/12/2023, are interfered with and set aside. We have said initially have said 17 actually. You are aggrieved by a decision of the Assam Board of Revenue. What is the date of the order? The date is 21/10. What did the ABR do? What was the issue before the ABR? Response number R6 filed a mutation case. It was rejected. Petition for mutation was rejected, was dismissed. But thereafter, against ADC's decision. Yes. Who was this Parshuram Bharali? Who was he? Hmm. You are the you are the sons and daughters of Parshuram Bharali. Petitioner is the son of Parshuram Bharali. So Parshuram, your father was the patta holder. Then what did the respondent do? Respondent number 6. They filed an application. Krishnaram. Krishnaram. Parshuram, Krishnaram, and two more. Two more sons. Okay. Pramod and no, one more. Padmaram and Pramod. Hmm. Are you projecting? Are you contending that your father has acquired the land on his own? It was not not ancestral land. Uh, Parshuram has purchased the land on his own. Mr. Saikil? If it is self-acquired property, you will not have any right. 28, yes. The Jamabandi. Yes. Okay, 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 we'll come to you. Let Mr. Okay, we will come to you. We'll come to you. Page 16. Annexure 113 probably, not 16. Or the SM is vernacular. Okay. Just a minute. Where are you? Porsuram Bhurali Pitakano. Yes. Serial 9. Yes. But what about that page 28? Page 28 pertains to the same land, same plot of land. But that is your document. But 28 is an annexure in your. You wanted to show this, that this is a manufacture based on which they have obtained the. Madam Sakya, today your chance is less. Unnecessary, you will be waiting. We can try. We cannot assure. That day also, Mr. Sharma and Mr. Sakya will have a case before you. No, I just we can have it. We can try on Tuesday. Let us we'll list it on Tuesday. Your case of which year? 19. How is the case of 19 pending? This is the case of 24. You should have 19. Huh? Hearing. Oh, hearing. Okay, okay. Yours is a hearing matter. Oh, yours is in the hearing column. Okay, you make a mention on Tuesday at 2 o'clock. Because if you are taking up for disposal, we'll try to take your case first. Admission, we are taking admission hearing, in fact. We are trying to dispose at the admission stage. We could have given preference to your case, 19 matter. Next Tuesday. Huh? The paucity of time. Yeah, okay. You have tried to show that at page 16, no, page 16, first, that Jamabandi has got your name. And there is no reference that you inherited the land from your father. Only you have, it has been written that you are son of Kanu. That's all. But not inherited from Kanu. And what is 19? Your name is Paresh or your name is Munindra? What is your name? Paresh is the petitioner. And Mr. Soikia, you are Munindra. R6. So R6 was the appellant. Before R6 is also was the appellant in ADC. Okay. What happened? Kanu. Yes. $28. So this is a certified copy. Where have you stated this? This is something very important. No, where have you stated? Which paragraph? No, this is your application. Where have you stated in the affidavit, in the present writ petition? There are 9. Yes. Did you contest in the ABR? Didn't you point out this that this is a manufactured document? What is the finding? Document. Okay. Okay. Page 31. Yes. Where is the discussion in this order that regarding your objection that the document which was sought to be introduced is a forced document? No, see, it hinges around two documents. While the document which you are relying would show that though you are the son of Kanu, you did not inherit the property from Kanu. You had self-acquired the property. Mr. Saikia would contend by referring to 28 is that the land originally belonged to Kanu. And from Kanu, you had inherited, and therefore his father also being one of the sons of Kanu. So one portion would also go to his father. And therefore he would also have a claim. Now, there are two documents before us. One is the document which Mr. Saikia has, it's a certified copy which he has obtained on page 28 is, I've just noted the date. It is on 6/12/2020, 6/12/2023. 6/12 is a certified copy. And what is your, which document you are relying upon, Mr. Sharma? What is this? 19th Sonor? This is draft SITA. That is not draft SITA. What is this? The, yes. No. Yes. No, writing Pita will not do. It has to be, it has to be discernible that she had inherited the land. Just like page 28, you said there is an Agabura, Aru, Kanuram, or okay, what is স্থলত পরেশ ভরাদের নাম নামজারি হয়. So it becomes apparent that Kanuram was the original. But from the document which Mr. Sharma is relying upon, it is not how the land, there is no Montebo, there is no remark. How was the land acquired? How did you procure the land? Did you purchase it? Did you inherit it? There is no. No, this is not the Jamabandi. This is a draft Chita. Chita will not have a Montebo. That's another document. Montebo is very important. Remark column. From how did you procure the land? If no remark is, and there is a document which contains a remark. Yes. Which page? 19, whereby his application was rejected, declined. Yes. Mr. Roy, records would be necessary. Do you have the records? What does the parawise comment say? Which order? But 19 has been set aside by the ABR, which is the subject matter challenge in this petition. You get the records. See, there are two documents. Both the documents are not for the very purpose, same purpose. One is a draft, one is a draft chita, and one is a draft Jamabandi. Jamabandi has a remark column, Montebbo, which says that in place of so-and-so, he's come. So it becomes apparent that Kanu was the original, but the document which Mr. Sharma is relying, there is no such remark, number one. There is only a name of the present patadar, present name of the present person whose name is on the record. But there is no remark from where he has obtained. And number two, he is also depending on the order of the learned additional deputy commissioner, who, while recording his findings, has referred to the records that there was nothing on record to show that Kanu was the patadar. So based on that, you get the records. The original proceeding was of which year, Mr. Sharma? 22. I think we'll get the records. No, that is not, he's not disputing that he's your grandfather. Yes, whether Kanuram was the owner of the land. Mr. Sharma says that the land has been acquired, is a self-acquired property. Your page, your affidavit. 34. 80. Is it 9/2/2022? Yes. That we have already, we have made our own diagram. Kanu is your ancestor. Kanu has four sons: Parshuram, Krishnaram, Padmaram, and Pramod. You are the son of Krishnaram, and petitioner is the son of Parshuram. Yes. It is pertinent. Mr. Sharma, why didn't you sit and why didn't you both the parties sit and resolve? What do you do, Mr. Sekia? What do you do? Now what do you do? What do you do? What is the source of your living? You don't stay there. You stay there. And your client stays there. That- no, that is not his case. His case is his case is that this particular property under DAG number 844 is not the property of Kanuram. It was purchased by his father, Parshuram. Parshuram did not inherit the same from his father, and therefore he will not have any right, any claim. This is 63. His father was not a minor in 55. Mr. Saikya, he at the time of filing this writ petition in the year 2024, his age was 60. His age is 63. Age of Porage Bharali. In 1955, his father could not have been a minor. No, you said he was also a minor. No, he has inherited from his father, Parshuram. He has not said that he has purchased. He says that Parshuram has purchased. Parshuram could not have been a minor in 1955. His age is 63. Is it possible? 63? No, 63. But you may be correct also. Margin. Your father would have been a young boy of around 1920, maybe, or even less. How did he purchase property? Do you have the link document? How your father had procured this land? Because if you are relying on the aspect that this land was self-acquired, is a self-acquired property by your father, it was not inherited from your grandfather, then it has to be purchased from somebody. Mr. Roy, see, we will ask you to have the record, but the certified copy are of recent origin, but the records are of 55, 57. See, we need a very specific response from you. The land in question, which is, you have got the DAG number. We just need the history of the change of hands. At one point of time, it was owned by Parshuram. How did Parshuram got the land? Did he get it from inheritance from his father Kanu, or did he purchase? But that is all. If he had purchased, then Mr. Sharma has a case. If he got from Kanu, then Mr. Saikia will have one share. Okay, please write. Challenge in this writ petition has been made to a judgment and order dated 21/10/2024, passed by the learned Assam Board of Revenue in case number so and so, page number 31. Yeah? Also, the issue which would require a consideration is with regard to the ownership, or is with regard to the uh, to the land, to the land in question covered by DAG number 844. What is the DAG number? 844. Also, while the petitioner contends that the said land is a self-acquired property of his Parshuram, or self-acquired property of his father Parshuram, from whom he has inherited, comma. The response number 6 contains that the original owner of the land is Kanu, and both his both his father and the father of the petitioner are the sons of Kanu. First of all, to remove any doubts, or not to dispel any doubts, comma, let the relevant records be procured by Sri S.S. Royded and State Council. First of specific instructions are to be obtained with regard to the procurement, with regard to the aspect as to how late Parsuram Bharali was recorded as the owner of the land in question. First of, in other words, whether, instructions are to be obtained whether the land was a self-acquired property of Parsuram Bharali, or whether the same was inherited from his father Kanuram Bharali. Old, document number 793, old. Mark the description. Okay. So, yes, Mr. Roy, when can we have? We give a date. We'll see. We will give the details. List on, yes, when? Today is 10th. We have it on 24th. 25th. 25. Okay. No, we're not keeping perfect. This bench is continuing. We don't. This code does not make any part unless we have it for tomorrow. After 2 weeks, you are going to forget everything. After 2 weeks, we will not remember anything. Okay, rest. Courtmaster will give dates. If there is any matter where interim order is still today? No. He'll give dates. No, 23. Yes. Excellent. What correction? But in the petition also you have written wrong address. Where is the office note? What should be 10? 10 is what? 10 and 11. 10 and 11 is the same. But there is a mistake in the address written on the petition as well as the address uploaded in the CIS in respect of response number 10. Different thing. Uploaded in the CIS and the others uploaded. Corrected. CIS গন্ডগোল করেছে কোর্ট কে বুঝিয়ে বলবে অফিসের চালু না whenever it comes from office different from the writ petition that from the address uploaded in the CIS CIS এর পর ভুল করেছে তো এটা কোর্ট কে বলে CIS এর পর বলে heard Sri Roy SK Roy learned counsel for the petitioner also heard Sri J. Hendrik learned state counsel full stop. In this case, notice was issued on 30/7/2025 and what about the others? 30/35 and the same was confined only to the official respondents full stop. Subsequently, comma, wide and order dated 13/2/2026 notice has also been issued to the respondent numbers 8/02/11 and steps were directed to be taken. Wide speed post full stop. Office note dated 24/2/2026 has however indicated that so far as the address of the respondent number 10 is concerned, there is a difference with the address mentioned in the writ petition and that uploaded in the CIS. Full stop. Full stop. And accordingly, notice could not be issued. Full stop. Para? It is failed to be understood as to what has restrained the office to make the correction in the CIS when admittedly a correct address has been written so far as the respondent number 10 is concerned. Full stop. The subsequent office note dated 7/3/2026 also appears to be factually incorrect as there is no as it has been clarified that there is no error while describing the address of the respondent number 10 in the petition. Full stop. Para? Office is accordingly directed to make necessary correction in the CIS with regard to the address of the respondent number 10 and issue the notice and disperse the notice as per the steps taken to the said address immediately, forthwith, full stop. List after 4 weeks along with service report. 4 weeks, service report.